Hello friends, I am Dr. Rangeen Pallav Tripathi. I am a faculty of law at National Law University, Odisha, and today we will be discussing about the module titled General Exceptions Part A. The basic objectives of this module are the following: to understand the scheme of the chapter of general exceptions in the Indian Penal Code, to understand the exception of mistake, to understand the exception of accident, to understand the exception of judicial and executive acts, to understand the exception of necessity, to understand the exception of immaturity, and to understand the exception of insanity, and lastly to understand the exception of intoxication. Chapter 4 of the Indian Penal Code is titled as General Exceptions, which deals with the principles under which the criminal liability of an individual is exempted. These exemptions operate as the defences which are set up when an accused is not disputing that he committed an alleged act but claims that he is nevertheless not liable due to the applicability of the provisions of Chapter 4. For example, suppose X is accused of stealing the watch of Y. There are two defenses which X can put up. The first one is he says that I did not take the watch. The second one is that I took the watch but I will still not be liable because of the applicability of any of the provisions contained in Chapter 4 of the Indian Penal Code, that is any of the general exceptions. The second part is where he is not disputing. The second argument, the second defense is where he is not disputing that he did not take the watch. He is agreeing to the fact that he took the watch, but he is saying that he is nevertheless not guilty. The provisions covered in Chapter 4 can be divided into two broad categories. First is excusable defences, second is justifiable defences. In this module, we will be talking about the excusable defences, which are provisions which are contained from Section 76 to Section 95 of the Indian Penal Code. These are the provisions where the act committed by a person is excused due to the lack of mens rea. These exceptions in essence deal with the absence of mens rea as the rationale for exemption from criminal liability. These cover reasons like mistake, accident, insanity, etc., which preclude the formation of the necessary intent in order to necessitate the imposition of criminal liability. Justifiable defences refer to the right of private defense. The rationale for exemption from criminal liability is not built around excusability but around justifiability. That is, the person says that he was justified in what he did. These cover circumstances where, due to the considerations involved, a person is held justified to have committed the acts that he did. The first part of the excusable defences comprises of the following grounds. First, mistake. Second, accident. Third, judicial and executive acts. Then necessity, immaturity, insanity, and intoxication. Let's start with the exception of mistake. Mistake is generally defined as a perception or belief which does not correspond with the reality of the situation. The legal provisions concerning mistake in the realm of criminal liability are incorporated in Section 76 and 79 of the Indian Penal Code. For a person to claim the benefit of Section 76, the following ingredients need to be proved. First, an act is committed by X. Second, X is bound by law to commit the act. Or third, X by reason of mistake of fact believes himself to be bound by law to commit the act, and he believes that he is bound by law in good faith. The reason behind X's belief is a mistake of fact and not a mistake of law. If all the above ingredients are fulfilled, then X will not be liable criminally even if the act committed by him constitutes a crime. Thus, Section 76 deals with a scenario where a person mistakenly thinks that he is bound by law to do something as long as the belief was in good faith and was based on a mistake of fact. Good faith refers to a state of mind where the person is taking due care and attention. When a person does something without taking due care and attention, the act is not said to have been done in good faith, even if the intention was bona fide. The section categorically mentions that if the belief was based on a mistake of law, the benefit of section 76 is not available. This section incorporates the Latin maxim ignorantia facit excusat, ignorantia lesis neminem excusat. This maxim establishes that while a person can be executed for ignorance of fact, he cannot be excused for ignorance of law. To understand the implications of this particular maxim and section 76, let's consider an example. X is a police officer. He is tasked with executing an arrest warrant issued by Y and issued by A and arrest Y. In furtherance of the warrant, X searches for Y, makes due inquiry and then arrests Z, thinking Z to be Y. In this scenario, X will not be liable for the wrongful confinement of Y as he was executing an arrest warrant which he was bound to execute. The mistake committed by him was in the identity of the person to be arrested. He thought he was bound to arrest Z under the mistaken belief that Z is Y. This is a fit case for the application of section 76 as the act is committed due to a genuine mistake of fact. Now let's make some minor alterations to the above example and consider the same. X is a police officer. He is tasked with executing an arrest warrant issued by A. In furtherance of the arrest warrant, X arrests Y. However, it turns out A did not have the legal authority to issue the arrest warrant. In this scenario, section 76 will not be applicable, as the mistake committed by X is not a mistake of fact but a mistake of law. He mistakenly believes that an arrest warrant issued by A is legally valid, whereas that was not the case. The mistake committed by him pertained to the authority vested in A by law. In both the above examples, the arrest of Z and the arrest of Y are wrongful. In the first case, Z should not have been arrested, and in the second case, Y should not have been arrested. The difference is in the nature of the mistake which led to the wrongful arrest. In the first case, the mistake was a mistake of fact, and thus X will be protected under section 76. In the second case, the mistake was a mistake of law, and X will not be protected under section 76. Section 79 is similar to section 76 with one vital difference. In section 76, the mistake of fact must lead the person to believe that he is bound by law to do something. Whereas in section 79, the mistake of fact must lead the person to believe that he is justified in law to do something. Section 76 deals with a scenario where the person believes that he is under a legal compulsion to do something. Under section 79, the person does not believe himself to be under a legal compulsion, but is of the impression that his actions are justified in law. Let us consider the following example. X notices that Y, a boy, is molesting Z, a girl, in a marketplace. X rushes to the spot and pushes Y to the ground. It turns out both Y and Z are actors, and the shooting of a movie was going on with the camera in the top of a nearby building. In this scenario, though X believes that Z is being molested, he is not under a legal compulsion to intervene. However, if Z was indeed being molested, it would have been legally justified under 97 of Indian Penal Code to defend Z. This is a scenario where X will not have a criminal liability for pushing Y to the ground. Now, let's discuss the exception of accident. The defense of accident is incorporated in section 80 of the Indian Penal Code. In order to claim the protection of this particular provision, the following needs to be proved. First, X was doing a lawful act in a lawful manner and by lawful means. Second, X was doing the act with proper care and caution. Third, the alleged offence happened out of accident or misfortune while doing the lawful act. Fourth, there was no criminal intention or knowledge on the part of X. In order to understand this better, let's consider the following examples. X is a racing driver and is participating in a race. Due to some malfunction in the engine, he collides with the barricade and one of the tires from his car hits a spectator. In this scenario, X is not liable. For the application of section 80, it is important that the accident happened while doing something lawful. Let's consider the following example. X is a thief and is trying to escape from police who are chasing him. X is on his bike and while trying to navigate, he hits a street vendor and injures him. In this scenario, X will not be entitled to the benefit of section 80. In the first example, when a person was driving in a race, he was doing a lawful act, and while doing a lawful act, an accident happened. In the second case, the person was doing an unlawful act, that a thief was trying to escape from police, and while doing the unlawful act, an accident happened. In the second case, the protection of law will not be available. However, it is important to remember that when accidents happen while doing an unlawful act, the benefit of section 80 will still be available if there was no causal connection between the unlawful act and the resulting harm. Let us consider the example below. X is in possession of an unlicensed gun and while shooting a jackal in the jungle accidentally injures Y, who was hiding behind the bushes. While shooting the jackal, X had no reason to suspect that another individual might be hiding in the jungle. This is a scenario where X is not liable even though it was unlawful for him to carry a gun without a license. This unlawfulness of carrying the gun had no causal connection with the accidental shooting of Y. Y would have been injured even if X was carrying a gun with a valid license. The unlawfulness of carrying a gun without license did not contribute to the harm which was caused. Now, let's look at the third exception, that is judicial and executive acts. Section 77 provides that when a judge does something acting judicially in exercise of any power which is given to him by law or which he in good faith believes to have been given to him by law, the said act cannot constitute an offence. There is a distinction between the situation where a judge is acting within his jurisdiction and where a judge is acting beyond his jurisdiction. When a judge does something in exercise of authority duly vested in him, he enjoys absolute immunity. He also does not need to prove good faith in order to avail this benefit. When a judge does something without having the jurisdiction to do so, he is protected only if he acted in good faith. The protection under section 77 extends to only such acts which are judicial in nature. Judicial acts refer to the acts of a judge done while discharging his core function, that is adjudication of disputes. When the judge is discharging any administrative functions, the same protection is not available. While section 77 protects the judges who take decisions, section 78 protects the individuals who commits acts in pursuance of a judgment or act which are warranted by a judgment. The following are the ingredients of section 78. X does an act in pursuance of the judgment or order of a court, or does an act warranted by the judgment or order of a court. The act was done by X while the judgment or order was still in force. It is to be noted that X will be protected even if the court had no jurisdiction to pass the judgment and order if he believed in good faith that the court had such jurisdiction. It is to be noted that X will be protected even if the court had no jurisdiction to pass the judgment or order, if he believed in good faith that the court had such jurisdiction. Now we'll go to the exception of necessity. Section 81 incorporates the doctrine of necessity by providing that when an act is done to prevent some harm to person or property, the person committing the act is not liable. In order to claim the benefit of Section 81, the following need to be proved. X did something with the knowledge that it is likely to cause harm. X did that thing without any criminal intention to cause harm. X did the thing in good faith, and X did the thing to prevent or avoid some other harm to any person or property. If all of the above ingredients are present, X will not be liable for any harm caused by his actions. However, whether the harm supposed to be prevented or avoided, justified or excused the harm actually caused is a question of fact to be decided in each case. Let's take this example. X knocks over Y, who was on his way while rushing to save Z, a baby, from being run over by a truck. Y breaks his leg because of falling down. Here, X is not liable. The harm which he sought to prevent was of a nature which justified his actions. That is, if he had not pushed over Y, a baby would have been killed. So, in order to prevent the greater harm, Y had to suffer a less greater harm. Now, consider this example. X knocks over Y to retrieve a basket of grapes which had fallen on the road and were about to be quashed by a running vehicle. Here, X is not entitled to the protection of Section 81. The harm which he sought to prevent did not justify the harm that he caused to Y. Now, let's look at the exception of immaturity. Section 82, which deals with absolute immaturity, and Section 83, which deals with qualified immaturity of the Indian Penal Code, provide for exemption from criminal liability when due to infancy, the individual committing the crime is deemed to be not in a position to form the necessary intent. Section 82 provides that anything done by a child under the age of 7 is not an offence. When a child is below the age of 7 years, there is a conclusive proof against the capacity of the child to be capable of understanding the nature of his acts. A child below the age of 7 is held to be dolly incapax, that is, a person incapable of forming intent, and thus such a child cannot be held criminally liable. So, if a child of 5 years of age commits theft, then no amount of evidence will ever be accepted as to whether that particular child was capable of knowing the nature of his act or not. The very fact that he is under the age of 7 will be sufficient to exempt him from all criminal liability. Section 83 provides that when a child above the age of 7 years but below the age of 12 years commits an offence, he is not liable if he did not have sufficient maturity of understanding to judge the nature and the consequences of his actions. It needs to be noted that the immunity granted under Section 83 is not absolute but qualified. If the child is under the age of 7, his incapacity is a conclusive proof and there is absolutely no possibility of any criminal liability. When an act is committed by a child above the age of 7 but below the age of 12, he can be held liable if it can be proved that he had the maturity to understand the nature and consequences of his actions. That is, a question which is not considered at all when the child is below 7 becomes a matter of consideration when the child is above the age of 7 but below the age of 12. That is, when a child of, let's say, 9 years of age commits theft, he will not be exempted of criminal liability just like that. The court will be empowered to inquire into the fact as to whether that particular child was aware and had the maturity to understand the nature and consequences of his act. If it is found that he did not have the capacity to understand the nature and consequences of his acts, he will be exempted. On the other hand, if it is found that he had the necessary maturity to understand the nature and consequences of his acts, he will not be exempted from his criminal liability. Now, let's look at the exception of insanity. The defense of insanity is applicable in situations where the accused is incapable of forming the intent necessary to incur criminal liability. A person cannot be held liable for the acts committed by him if he lacks the mental capacity to understand the nature of the acts being committed by him. To claim this particular defense under section 84, the following ingredients need to be proved. Firstly, at the time of committing the offense, X was of unsound mind. Second, because of his unsoundness of mind, X was not capable of knowing the nature of the act at the time of committing the offense, or because of the unsoundness of his mind, he was not capable of knowing that he was doing something either wrong or contrary to law at the time of committing the offense. Section 84 is based on the Macnaghten rules which originated in England. Legal insanity covered under section 84 is different from the concept of medical insanity. In medical science, there are several diagnoses concerning the state of the mind and several types of mental disorders recognized. Section 84 is not concerned with every medical diagnosis of mental unsoundness. It is only concerned with such unsoundness of mind which affects the capacity of a person to comprehend the nature of his acts. There is no limitation on the nature of mental conditions which is covered under section 84. The only requirement being that the said mental conditions must have impaired the capacity of the individual to know the nature of the act, or that what he was doing was wrong or contrary to law. Even if a person medically diagnosed as being of unsound mind, he will not be entitled to the protection of section 84 if the said unsoundness of mind did not result in the impairment of his knowledge of things. That is, even if a person is diagnosed as medically insane, that does not mean that he will get the protection of section 84, which is provided on the ground of legal insanity. Unsoundness of mind, which affects the emotional control of a person, is not covered under section 84. A person is also excused from criminal liability if he could not know that what he was doing was wrong or contrary to law. Although in England, under the Macnaghten rules, the term wrong is understood as a legal wrong and not a moral wrong, the use of both the words wrong and contrary to law in section 84 means that the term wrong in section 84 includes a moral wrong. Now, let's discuss the exception of intoxication. The Indian law intoxication has been incorporated in section 85 and section 86 of the Indian Penal Code. The law provides protection to a person only when the person has been intoxicated involuntarily. If the person has consumed the intoxicating substance voluntarily, he is afforded no protection. The following are the ingredients of section 85. First, X was intoxicated at the time of committing the offense. Second, the thing which intoxicated him was administered to him without his knowledge or against his will. Third, due to the intoxication, he was incapable of knowing the nature of the act he was doing, or due to the intoxication, he was incapable of knowing that what he was doing was wrong or contrary to law. Section 85 has the same construction as section 84, with involuntary intoxication substituting unsoundness of mind as the factor impairing the capacity of the person. The term without his knowledge refers to a situation where the person was not aware of the fact that he was consuming an intoxicating substance. On the other hand, against his will refers to a situation where the intoxicating substance has been administered to the person by force or compulsion despite his resistance. Thus, When a person consumes an intoxicating substance voluntarily, the protection of Section 85 is not available. Section 86 provides an explanatory principle to Section 85. It provides that a person under voluntary intoxication is deemed to have the same knowledge he would have had if he had not been intoxicated. In offences where particular knowledge on the part of the accused needs to be established, a state of intoxication shall not operate as an excuse for lacking that particular knowledge if the person had been intoxicated voluntarily. It will be presumed that he had the necessary knowledge. However, the same presumption does not operate when the offence requires proving a particular intent. The said intent cannot be presumed to exist even if the person was voluntarily intoxicated, and it must be proved through evidence. That is, when I am voluntarily intoxicated and the crime for which I have been accused requires me to have a particular knowledge, it will be presumed that I had that particular knowledge. On the other hand, if I am voluntarily intoxicated and the crime for which I have been accused requires a particular intention on my part to be proved, that intention will not be presumed but has to be proved by the prosecution by evidence. If we are to summarize these modules, then the following needs to be kept in mind. The chapter on general exceptions can be thematically discussed in two parts: excusable defenses and justifiable defenses. Mistake of fact is an excusable defense when the person acts on the belief that he is either bound by law or justified by law to commit the act. Section 80 exempts a person from criminal liability when any harm is caused by accident while he was doing something lawful, as long as he has exercised due care and caution. Anything done by a judge in his judicial capacity or anything done by a person in order to execute the judgment or order of a court will not result in criminal liability of the judge or of that person. The doctrine of necessity, as incorporated in Section 81, protects a person from criminal liability for any harm caused by him if he caused such harm in order to prevent some other harm. Section 82 confers absolute immunity on a child below the age of 7 years, while Section 83 confers qualified immunity on a child above the age of 7 years but below the age of 12 years. Section 84 excuses a man from criminal liability due to the unsoundness of his mind if he could not know the nature of the acts or that what he was doing was either wrong or contrary to law because of such unsoundness of mind. Section 85 excuses a man from criminal liability when due to intoxication he could not know the nature of the acts or that what he did was contrary to law or that it was wrong, provided that the intoxicating substance was consumed by him without his knowledge or against his will. That would be all. Thank you.